All right, let's jump right in. If you're facing debt buyer arbitration, this is for you. We are going to break down the arbitration playbook into a straightforward guide that puts you back in control. So let's get to it. And we have to start right here with what is probably the single most important idea in this entire strategy. This is a total mindset shift. Forget playing defense. Forget reacting to what they do. From now on, you are on the offense. You are actively testing every single piece of their case, and you're just waiting for it to crumble. Now, to test their case, you first have to really understand who you're dealing with. It's time to pull back the curtain on how these debt buyers operate and, really see the illusion they're counting on. Here's their whole secret. It's a numbers game. That's it. They buy up thousands, literally thousands, of old accounts for pennies on the dollar. Then they just file claims on everybody, betting that most people will just give up and not fight back. Their entire business model is built on quantity, not quality. And that, right there, is their biggest weakness. You see, this whole volume-based model, it's just full of holes. Because they're moving so fast and dealing with so much, the paperwork they get is frankly a mess. The person they send to the hearing, they have absolutely no firsthand knowledge of your original account. They're just some employee reading off a computer screen. Their whole system, their entire business, depends on one thing: you doing nothing. The second you decide to act, their illusion just shatters. So, knowing all their weaknesses, how do we exploit them? It's simple. We are going to completely flip the script. We're going to put you in the driver's seat. See, they want you to play their game. They want you reacting to their claims, feeling completely overwhelmed and basically just hoping things work out. But we're not doing that. We're playing your game now. You're not reacting anymore. You are forcing them to prove everything. You're the one taking control and executing a plan. And the reason you can do this, your ace in the hole, is a powerful legal principle called the burden of proof. This is so important. It is not your job to prove you don't owe anything. It is 100% their job to prove with actual, legitimate evidence that you do. All the pressure's on them, not you. So what do they actually have to prove? It really comes down to these three things. First, they have to prove they legally own this specific debt. Second, they have to prove the amount they're claiming is 100% accurate. And third, and this is a big one, they have to prove that the documents they're showing are even allowed as evidence. If they stumble on just one of these, their case is over. Okay, so we have the mindset. We know the law is on our side. Now let's get into the big picture strategy you're going to use to take their case apart. I call it the three-layer attack. See, we're not just going to make one move. We're going to apply pressure from every single angle. There's legal pressure, where you use the rules to challenge everything they do. There's financial pressure, where you make this case so expensive and time-consuming for them that it's no longer profitable. And then there's psychological pressure. You show up confident, you know what you're doing, and you make it clear you are not backing down. A volume business just can't handle that kind of focused, intense pressure. So that's the strategy. But how do you actually apply all that pressure? Well, let's get down to the nitty-gritty and look at the actual tools you have in your arsenal. Let's start with your most powerful tool, your opening haymaker, the motion to dismiss. This is a formal request you make to the arbitrator to just throw their case out before it even really begins, because it's so weak and lacks basic proof. And these are the grounds you use. Look familiar? Each one of these is a direct attack on the weaknesses we've already talked about. You're basically saying, hey, they can't even prove they own this, or their key document is just hearsay, which really just means it's secondhand info from someone who has no personal knowledge of what happened. You're forcing them to show their cards right from the start, and they often have nothing to show. Okay, but let's say the case does move forward to a hearing. Your next tool is what I call the objection system. This is how you control the flow of the hearing itself in real time. It's how you stop them from getting improper or flimsy evidence into the record. And a huge part of this is asking really simple but really powerful questions. When they show a document, you just ask their witness, who created this document? Now, since they work for the debt buyer, not the original bank, the answer is almost always going to be, I don't know, or someone else did. And just like that, you've shown they have no personal knowledge of the very evidence they're trying to use. So these objections become your go-to moves. When their witness starts talking about a statement they didn't create, you say, objection, hearsay, or lack of personal knowledge. When they try to use some random printout without proving where it came from, you say objection, lack of foundation. You're not arguing, you are simply enforcing the rules of the game. So let's put it all together. When you combine this offensive mindset with that three-layer strategy and you use these precise tools, what you have is a complete system for controlling this entire process, from the beginning all the way to the end. And this is what happens. You're no longer the person just being dragged along for the ride. You control the motions. You control what evidence gets in. You control their witnesses. You control the objections. You control the whole strategy. And when you control all of that, you control the outcome. Because in the end, it really all comes down to this one simple, undeniable truth. The entire burden of proof is on them. And if you use this playbook to test their case, to challenge every piece of their so-called evidence, you're going to discover that most of the time, they just can't prove it. And if they can't prove it, they can't win.